This is a record performance, Bruno. Absolutely, absolutely. Thanks a lot. I will now move to the next speaker, who is Peter Jago. Peter Jago is a partner of Moore, Fisher and Brown, and he will tell us about the recent developments of the Interclub agreement. Please, Peter.
Thank you. Good evening, and I'll try to beat Bruno's recently set record. I simply want to refer to the Interclub agreement today because it's been amended this summer. The amendment has been very well publicised by the International Group of Clubs, so you all probably know about it, but I just thought I'd take this opportunity to bring it to everyone's attention, just in case it slipped through the cracks in anybody's knowledge. The Interclub agreement has been around for 41 years, and this is only the fourth substantial amendment, so it's a pretty hardy tool. It applies to the dry side of the market, to bulk cargoes and containers. It's for use with the New York Produce Exchange form or the aspartame form. So tanker owners amongst us will be bored by this part of this evening. The aims of the Interclub when it was introduced was to provide a quick and easy mechanical adjustment of cargo claims to avoid lengthy and costly investigations, and probably to avoid lawyers as well, which is always commendable, but lawyers seem to have muscled in on it. One thing that I don't think it was ever intended to do was to prejudice a party who has had to provide security. The classic situation is that the ship arrives at a discharge port, the cargo is damaged, the bill of lading holder, the receiver, attacks the nearest obvious target, which is the ship, arrests the ship, and the ship owner has to provide security. However, it's not all one way, because of course the cargo may be carried under a charterer's bill, and the receiver might proceed against the charterer, particularly in the container trade. So up until this summer, and the amendment on the 1st of September of this year, there has been a great debate about whether, if in my classic example, the owner has to put up security, can he obtain counter-security from his charterer? And the answer generally has been assumed to be no. It's been more than assumed in some places. In South Africa, there were a couple of judgments which said absolutely not. And the reason for this was an interpretation of Clause 4C of the 1996 version of the agreement. But it was thought that security couldn't be obtained until the claim was settled and liability was incurred by the ship owner. Now, this was very disadvantageous because we all know, or those of us who defend cargo claims on behalf of owners know that an investigation into the cause of the damage can take time, and sometimes a better result can be obtained if you prolong the period in which the claim is brought, if you spin it out a little bit, if you arrive with your checkbook as soon as the claim arises, you might be paying more to settle it. So, but in the meantime, the owner couldn't obtain counter-security from the charterer. What happens if the charterer goes bust? Well, the owner was left high and dry, even though the Interclub gave him a potential right of recourse. Same for a charterer. If the charterer did have to provide the security, they couldn't get security from an owner. Owner may be at one ship company, ship may be sold, ship may be scrapped, so they would be left without recourse. So just to mention then, the amendment that has taken place now allows security to be obtained. I won't read it because it'll take time, but if in my example the owner has had to provide security, he can now go and demand security from the charterer. Of course, the charterer may not give it voluntarily, so the owner then has to try and find assets, arrest those assets, but at least under English law, the courts will allow an arrest to take place, and the same will be this will be interpreted the same in many foreign jurisdictions. So security can now be obtained, and each party can protect its position at that stage. But so that swept away one game that was played perhaps by lawyers or certainly by parties, this hedging around trying to obtain security, trying speculative arrests. It was all very time-consuming and costly. So that should streamline the operation of the interclub agreement to some extent. That leads me to just ask very briefly, well, where does that leave the interclub agreement? How well is it serving its purpose of speedy mechanical settlement of cargo claims, avoiding lawyers if you can? And in preparation for today, I spoke to a number of claims executives at P&I clubs, and the answer is a little bit mixed. It's people use the interclub, but very rarely will one club receive a claims package from another with a demand for payment and just write a check and send it off. And, usually there's a little bit more debate than that. I mean, this is because of the nature of the interclub itself. It divides responsibility for cargo claims amongst different types of claims. So unseaworthiness, 100% owner's responsibility. Water coming in through the hatches, that's a fairly good sign of unseaworthiness that's hard to defend, and so the owner will pay. Poor stowage is usually, if the charterer has taken on the responsibility for stowage, usually 100% charterer's responsibility. But I've been involved in many cases of containers falling off ships, and you have this tension, or you have this investigation to be made. What caused it? Under English law, we tend to try to establish the proximate cause. That's the most dominant cause, because that way justice is done. But these cases can be very expensive to investigate because you have all the issues of lashing to investigate, and the stowage of the containers, the stack weights, the tier weights. Were the lashings defective? Were they installed correctly? And then you have seaworthiness issues. What about the navigation of the ship? Did the ship just head straight off into a force 8 gale without slowing down and without adjusting course? And if it did, was that prudent? So what was the cause? And with these container losses, you can end up with in the hands of naval architects who produce a very scientific analysis of all this, but very costly. So
Even worse than lawyers.
Well, thank you, Bruno. But Ugo, sorry, you may be right. And I just have a suggestion. I haven't thought it through particularly well, and it may be nonsense, but on the big cases, I think we will need the interclub as it stands, so that owners and charterers can go and investigate the proximate cause. But for smaller cases, the costs would just outweigh the amount at stake. What is a smaller case? Well, maybe $50,000 for, say, per bulk cargo, maybe $20,000. But for a small case, what should we do? And one suggestion would be to introduce another regulation which says the interclub only applies to claims over the threshold limit, but beneath that, 50-50. Just call it 50-50. Keep lawyers out of it, keep surveyors out of it. P&I clubs may not have to expand their claims handling department so much, just 50-50. Now, one of the disadvantages, I can see an owner might say, look, I run my ships well, I manage them well, I equip them well, I train my crews well. Under my charters, charterers responsible for stowage, why should I pay 50%? Well, that's a good argument, but we've got to be pragmatic in these circumstances. And if it's set at a level that people can live with because the costs will outweigh the benefits of the investigation, I just throw open that to those people who sit on the committees that decide these things to consider putting a threshold in now to avoid the costs of smaller investigations by a 50-50 apportionment up to a certain level. My last comment is the mechanics of this will have to be carefully thought through, but say 50-50 for a bulk cargo for container vessels, sorry, 20,000 or 50,000 for bulk cargo for container vessels, maybe 5,000, 10,000 per container, up to a limit, an aggregate limit, so that if 20 containers fall over and you're over the 50,000 limit, then you're back to the interclub. So there's been one amendment and one suggested amendment to further streamline the interclub agreement. Thank you.